Hello everybody and welcome back to another episode of Law Scope. I'm Sana, I'm the legal expert for Hitbullseye, and in today's video we shall be discussing some important judgments and some important topics of law which have happened in the last 15 days, that is from 15th May to the 31st of May, that is today. So let us start with the video. First of all, we shall be discussing the case of D.N. Singh versus the Commissionerate of Income Tax. This is a case wherein the Supreme Court basically said that a thief cannot be the deemed owner of a particular property in order for it to be taxed. So essentially, the facts of the case, the background was that the the assessing officer had taxed a particular person or had taxed a particular firm, that is Mrs. D.N. Singh. So Mrs. D.N. Singh was a common carrier, and it was supposed to pick up a consignment and drop it to another person. However, it failed to deliver it to the person who it was assigned to be delivered, and the consignment of bitumen remained with Mrs. D.N. Singh. So, in this case, the assessing officer applying Section 69A of the Income Tax Act had put taxes on it. So, what does Section 69A of the Income Tax Act states? Basically, it allows the assessing officer to put any unexplained money, any unexplained resources, basically anything like any unexplained bullion, jewelry, or any other valuable article that the person might have, and he is not able to explain the source of that particular income, then the assessing officer can take it as the unexplained income of the person and can put it in essentially as taxable income. All right. So basically, what had been done after the assessing officer had put it in taxes, the Patna High Court had agreed to the same, and the case further went to the Supreme Court. The Supreme Court stated that the thing that never belonged to that particular person. The consignment never belonged to the person who was being taxed for it. If a person is being taxed for something that he has stolen as an unexplained money, unexplained income, in that case the result is going to be very absurd. The result is going to be very startling, in the sense that he shall not have essentially the rightful ownership of that particular thing. So in this case, the Supreme Court stated that a thief cannot be assessed for the same. So in our next case, and a very important case, Glock Asia Pacific Limited versus the Union of India. In this case, Chief Justice basically D.Y. Chandrachud, Justice P.S. Narasimha, and Justice J.B. Pardiwala. It's a three judges bench basically. In Glock Asia Pacific Limited versus Union of India, the Supreme Court has stated that Article 299 is not going to give any immunity from the statute merely because the contract was entered into in President's name. Now, what does it mean and what was the facts of the case? Let us try to understand. Basically, Glock Asia Pacific Limited for making pistols. So the Union of India, that is the Home Ministry of India, got into an agreement with the Glock Asia Pacific Limited, the company. It is a foreign company. So the Union of India, the Home Ministry, got into a contract for a purchase of some Glock pistols in 2011. Now, in basically the tender, the method, in case any dispute arose, the method for dispute resolution was that the Ministry of Home Affairs is going to appoint any person from the Law Ministry, from the Ministry of Law, in order to act as an arbitrator. So essentially, the sole right of choosing an arbitrator belonged to the Home Ministry only and not the other party. If we come to what are the general rules that are followed in appointment of arbitrators, it is given under Arbitration and Conciliation Act of 1996. Let us have a look at the relevant provisions under the Arbitration and Conciliation Act. First of all, for the appointment of arbitrators, Section 10 says that number of arbitrator depends on the persons, but in case no particular number has been given, then the sole arbitrator will be appointed. In this case also, both the parties had already contemplated that there is going to be a sole arbitrator, but how he is going to be decided? When Glock Asia, when the dispute arose, then Glock Asia Pacific Limited put a request for appointment of a particular judge who was a retired judge of the Delhi High Court. However, the Union of India party rejected this thing, saying that they had a right to choose a person from the law ministry itself. So in this case, if we see under section 11, how is a person appointed? In case there is a sole arbitrator, it has to be appointed by the consensus of both the parties. Both the parties have an equal say in choosing of the arbitrator. And then if there are three or let's say any number of odd people in the panel of arbitrators, then one arbitrator has to be selected from one party, another arbitrator has to be selected from the other party, and both the arbitrator choose the presiding arbitrator, essentially. Sorry. In case both the parties fail to come to a conclusion within 30 days from receipt of request of arbitration from one party, in that case the case goes to either the Supreme Court or the High Court. In this case, since it's an international commercial arbitration, so the case goes to the appointment of the arbitrator has to be done by the Supreme Court, and the Supreme Court shall tell as to who shall be the rightful arbitrator. So, after that, Section 12 of the Arbitration and Conciliation Act gives some provisions about the independence of the arbitrators. So, it essentially says that the arbitrator is required to be absolutely impartial, and he has to in fact give a declaration that first of all he will be able to do it without any impartiality, without any bias whatsoever, and it can be any kind of bias, personal bias, pecuniary bias whatsoever. And the second thing that it states that is that that he has the requisite time in order to solve the dispute. And if it is found out under section 12 subclause 5, it is found out that there's any relationship with the one of the arbitrators has any relationship with one of the parties, then and any relationship, all these relationships have been described under sections schedule 7 of the Arbitration and Conciliation Act. So if there's any relationship, what can be the relationship? If a party is, say, an employee, consultant, advisor, any kind of a relationship between one arbitrator and one party, then the arbitrator cannot be chosen, because that person will be deemed to be an impartial arbitrator. And isn't it the first rule of natural justice, nemo iude in sua causa? So now coming to, this was the argument of the Glock Asia Pacific Limited, one party, stating that the arbitrator is not partial. Now let us look at the argument from the other side, that is the Union of India. The Union of India categorically quoted Article 299 of the Constitution, which talks about government contracts. It essentially says that all the contracts which are to be entered by the Union of India or which are to be entered by the state shall be entered in the name of the President or Governor respectively. So, further it states that neither the President nor the Governor shall be personally liable in respect of any contract or assurance made by or executed for the Constitution. Essentially, it is saying that the Governor and the President shall not be personally liable for any contract that is taken by it. So, if we see what is the nature of the government contracts, it was given under KP Chaudhary versus the state of Madhya Pradesh, and there are three facets to it. First of all, they must be expressed properly. Second of all, they must always be in writing. And third of all, the execution may be done in such a manner as the governor or the governor general may direct or authorize. So basically it is saying that even though, so basically it is essential to notice that while president is getting into a contract with any other party, or while the governor is getting into a contract with any other party for that matter, they're not doing it in their personal capacity, they're doing it as an executive function of the state. Right. So essentially, in Chaturbhuj Vitthal Das Jasani versus Moreshwar, Parashram, and others, it was held that what is the basic objective of Article 299 is that we want that there has to be a definite procedure according to which all these contracts are made, and in order to ensure that there's somebody who's doing it on government's behalf. So essentially, president is not signing the contracts himself or herself. There's an office of the president, or the president is authorizing somebody to get into the contracts on that behalf. Otherwise, it is going to deplete the government treasury, essentially. So in this case, finally, the Supreme Court stated that it is only essentially a method as to how to Article 299 is essentially a method as to how to get into a contract with the government, and it does not give the government any immunity that if they get into a contract with a private party, then the government is not going to, the say Arbitration and Conciliation Act, the impartiality clause, etc. is not going to apply to the government. It is not like that. The government is also equally liable, and especially in this case, the Supreme Court quoted the 246 Law Commission report, which stated that in these cases, the government has to be extra careful of the fact that there is no partiality in appointment of arbitrator in these disputes where one of the party is itself the government. And also, concluding the judgment, the Supreme Court appointed former Justice Indu Malhotra of the Supreme Court as the arbitrator. So this was essentially the ratio. This was the order given by the Supreme Court, stating Article 299 only lays down the formality that is necessary to bind the government with the contractual liability, and not the substantial law relating to the contractual liability of the government, which is to be found in the general laws of the country. So essentially, general laws, Contract Act, etc., it's going to apply. So now let us come to the third case of today. So essentially, this is Sri Shankaracharya University of Sanskrit versus Dr. Manu. In this case particularly, Justice B.V. Nagaratna and Justice K.M. Joseph discussed points about interpretation of amendments and provisions which are amending any law. So as you might know that all the laws are essentially growing with time. Law is an organic thing which is growing with the society, and time and again when one law is introduced, it is realized that it is not amply clear, then some kind of a clarificatory statement is given out. Now this clarificatory statement can be given out by the Supreme Court as a judgment, or it can be given out even by the, say, the ministry as an executive like order, or even by the legislature itself as an amendment. So how are these amendments going to be read? Amendments of law essentially are going to be read. The Supreme Court basically explained how to read these interpretation of statutes. In this case, the Supreme Court first of all pointed out that since amendment is amendment as to a clarification, whenever anybody is issuing a clarification, it essentially means that the law always existed like this, but we are making a clarification. We are explaining how the law is to be read, how the law is to be applied in the current situation. So that means that it will always in general be retrospective effect. And in order to find out how a judgment is going to be a judgment or any other thing is clarificatory for that matter, these are the rules that the Supreme Court has given. First of all, clarification is always retrospective. It is different from a substantive amendment to a statute. Whenever there is a substantive amendment, for example, increasing the time of something, decreasing the time of something, etc., or introducing any change in law, then it is different from amendment as to clarification. Clarification must not have the effect of saddling any party with an unanticipated burden or withdrawing from any party any unanticipated burden. So it should not interfere in the merits of the case. It should not confer onto the one party something that didn't exist before, but now we are just understanding how it existed. If a statute is curative or merely clarificatory of the previous law, the retrospective operation thereof may be permitted. So if it is only clarificatory, then retrospective admission is permitted. In order for a subsequent provision or amendment to be considered as clarificatory, what is the test? Of the previous law, the pre-amended law ought to have been vague or ambiguous. So it is essential that earlier the law was vague, it was ambiguous, it was not discernible, and that is why subsequently some clarification was issued which explains the whole case. An explanation clarification may not extend or alter the scope of the original provision, and merely because of the provision is described as the clarification or explanation, the Supreme Court is not going to take it on its face value. So essentially, even if the ministry or say the legislature is stating that a certain provision is only a clarification and nothing else, it is essential for the Supreme Court to go deep into the provision and understand whether it is actually an amendment in a substantive form or it is only clarifying something that always existed. So in our next case, let's come to Kunal Kamra versus Union of India. This has been a case that has been covered by the newspapers, etc. a lot, any which ways, because it is basically to do with the IT Amendment rules of 2023. So the IT Information Technology Amendment rules, Information Technology Intermediary Guidelines, and Digital Media Ethics Code. This is a code. The amendments were made back in 2023, in the former months of 2023. The bench, there is a Bombay High Court judgment. The bench of Justices Gautam Patel and Neela Gokhale has stated that the new amendment to IT Rules 2022 is prima facie, it lacks the necessary safeguard. The Bombay High Court basically stated. Now, if we talk about what are the essential changes that have been brought by the IT Amendment rules, it is basically something to do with censorship. As you might know, the Freedom of Press Index, our ranking, India's ranking on the Freedom of Press Index is already 161 out of 180 countries. So it's already way below. Now, what the government introduced was, this central government introduced certain rules in which fact-checking units are going to be made by the central government itself. Now, these fact-checking units are going to essentially check what are the fake, false or misleading information that are given on social media. So essentially, they are going to investigate news reports, any comments, anything that might be posted online, essentially anything that is posted on Instagram, Facebook or any other online platform whatsoever. So it permits censorship. The fact checking unit is going to flag those post, comments, etc., and it is going to tell the service providers or the intermediaries to not showcase it on their websites or whatsoever. So it permits censorship by online social media companies, ISPs and file hosting companies. So there are going to be due diligence requirements. It can stop any kind of thing, any kind of information that is going against the central government, that the fact checking unit finds false, fake or even misleading. So it can stop from publishing, transmitting, storing, updating, displaying, upholding, modifying or sharing any kind of information. So now essentially the court said it is imperative to make sure that the IT rules are not applied in a way to suppress the dissent or it violates the fundamental rights. The fundamental rights that are talked about here are Article 14 and Article 19(1) Clause A, that is right to freedom of speech and expression, and 19(1)G, that is right of trade. Then we come to our next case. This is also a case of a High Court case essentially, in which the Delhi High Court rejected a plea by the Dettol to stay Santur hand wash advertisement. Essentially, this is Ricket Benkisar India Private Limited versus Wipro Enterprises. The bench is Justice C. Hari Shankar. It dismissed the interim relief that was sought by Dettol to put a stop to the advertisement by Santur. So essentially, as you can see over here, this was an ad by Santur in which they are showing a bottle which is kind of resembling the bottle of Dettol, which is white in the body is white and the cap is green, and it says ordinary hand wash. So now, essentially in the Santur hand wash ad, they had told that it is better than all the ordinary hand washes, and here they had shown this bottle as a ordinary hand wash. Now we need to understand, in order to understand this, the Delhi High Court stated that it is not something that is honestly extremely denigrate and honestly disparages the product. So it is not something that is very insulting of the product, of the competitor's product. It is something that is that Santur is just indulging into some amount of puffery, and that's it. So in order to understand what is puffery, the Delhi High Court laid down certain guidelines as to what is allowed and what is not allowed. Puffery, if we talk about, is essentially the exaggeration, the habit of advertisement being exaggerated in order to basically exaggerate the qualities of the product. So the certain principles that were given was, firstly, puffery is sorry, puffery is permissible to a certain extent. So puffery is expected to a certain extent, and it is permissible also to a certain extent. It's expected to be exaggerated and extravagant, because it's not meant to be taken seriously by the people who are watching the ads as well. A certain amount of disparagement is implicit in puffery, because the companies are always going to say that our product is better than everybody else's product, the other products are not at par or something like that. So this is allowed. Denigration of rivals' goods is impermissible. So you cannot denigrate rivals' goods in the process. You can say from all the others, from the rest of the hand washes, from the ordinary hand washes, but you cannot say better than the Dettol's hand wash or something like that. So the advertised goods can be claimed to be superior to the rivals, but the rivals' goods cannot be told to be inferior. That is a minute difference. Words used in the advertisement are meant to be understood in their natural general sense. If the statement made in the advertisement is honest and without malignant intent, then the court is not going to attribute any kind of a malified intent to it. Then if the advertisement is clearly intended to be disparaging, then there's a possibility of the alternative. In case this is innocuous, then meaning it would be irrelevant and would not amount to disparagement. So even if there's any kind of denigration and it is that denigration is innocuous, that does not mean to disparagement, and that will not allow the high courts to take down the ads. The multiple meaning of rules is to be applied only where more than one meaning can be attributed to the recital or depiction of the advertisement, and there is a possibility that a certain viewers would accept the derogatory meaning. The reasonable viewer, who's the reasonable viewer? He's not naive. He can read between the lines. He understands when the other product has been denigrated. He may indulge in some amount of loose thinking, is not avid for scandal, and does not select a derogatory or a bad product. The court said that it should not have undertaken like over elaborated analysis. It should not, basically the courts in trying to understand whether something is denigrates the other product or not denigrate the other product, then it should not have to go in between the lines. It should be essentially prima facie denigrating the other product. So the court is required to examine the storyline, the intent of the message, and other things such as what is the message that will be received by the viewers. Factual representations are not permitted to be untrue, as the average viewer might ignore puffery, but he is not going to ignore something that is factually stated. The truthfulness of such assertions or statements of the facts is therefore to be strictly tested. So essentially you can indulge into puffery, but you cannot make false representations. This is all for today's video. We hope we'll come up with something more interesting in the next video. In case you have any doubts, please comment into the comment box, and please don't forget to like and share the video. Thank you, and see you in the next video.